Gary DeWaal here, and this is Bridging the Week from May 11th to 15th, and today is May 18th, 2015. Good morning. The chairman of the Commodity Futures Trading Commission intimated last week before a Senate committee that some regulatory relief might be forthcoming. Meanwhile, a non-United States cotton merchant was fined by the commission for not filing required reports after self-reporting its own infractions and correcting its mistakes, and the adjudicatory arm of the Financial Industry Regulatory Authority recommended tougher sanctions for certain offenses. This is the last Bridging the Week until June 1st, after the Memorial Day holiday in the United States, so let's get started so I can get on the road. Timothy Massad, chairman of the Commodity Futures Trading Commission, disclosed last week before the United States Senate Committee on Agriculture, Nutrition, and Forestry that the CFTC had become the second phase of a retrospective regulatory review to determine which CFTC rules, quote, may need to be modified or rescinded, end of quote. As part of this review, said Mr. Massad, the Commission will solicit public input and, quote, follow up with rulemaking proposals as necessary, end of quote. The chairman provided no insight into the potential areas for rulemaking. Separately, Commissioner J. Christopher Giancarlo severely criticized the CFTC's proposed position limit rules before the EnergyRisk Summit in Houston, Texas. According to Mr. Massad, the CFTC's reflective review is in response to a 2011 executive order of President Obama. Mr. Massad said that the first phase of the CFTC's retrospective review was its consideration of rules adopted in response to the enactment of the Dodd-Frank Act. He claimed that in response, the Commission modified a number of rules, quote, to reflect market developments and to codify standards or commonly accepted industry practices, end of quote. Mr. Massad told the committee that the Commission is looking at ways to improve its rules related to swap execution facilities and is currently considering comments received in response to its September 2013 concept release on automated trading environments to determine, quote, what further steps may be necessary to further reduce risks electronic and automated trading, end of quote. In his presentation, Mr. Giancarlo argued that because the run-up in oil prices prior to the 2008-2009 financial crisis, quote, did not bear any of the signs of excessive speculation, end of quote, there is no evidence to support additional federal position limits in the energy markets. Indeed, because liquidity may be decreasing outside of the spot month, quote, the current problem may not be one of excessive speculation, but of inadequate speculation, end of quote. Libero Commodities S.A., a non-United States-based agriculture trading company, agreed to pay a fine of $480,000 to the CFTC for not filing mandatory weekly reports of its cotton purchases and sales since it began trading in May 2010 through April 29, 2014. Under CFTC rules, all cotton merchants and dealers, wherever located, who hold or control futures positions in excess of reportable levels, 100 contracts for cotton, are required to file with the CFTC a Form 304 on a weekly basis setting forth all cotton bought or sold or contracted for purchase or sale at a price to be fixed later. According to the CFTC, on over 200 occasions during the relevant period, Libero failed to file with the CFTC a required Form 304. Libero, which is principally based in Geneva, Switzerland, and maintains an office in Mato Grosso, Brazil, self-reported its violations, said the CFTC. Cargill Incorporated agreed to settle a disciplinary action brought by ICE Futures US related to its alleged failure to expose multiple futures orders to the market for at least 5 seconds prior to crossing them on the exchange's electronic trading system against other orders following pre-trade communications. This requirement existed under a predecessor to ICE Futures US' current rule dealing with crossing trades. To settle this matter, Cargill agreed to pay a fine of $300,000 and to comply with ICE Futures US's pre-execution communication procedures going forward. The Financial Industry Regulatory Authority filed an administrative complaint against Scottsdale Capital Advisors Corporation, a registered broker-dealer and FINRA member, for the alleged sale of 74 million shares of unregistered microcap stocks of 3 United States incorporated companies from December 1st, 2013 through June 30th, 2014. In its complaint, FINRA also named D. Michael Cruz, Scottsdale's president, Timothy DeBlasi, its Chief Compliance Officer, and John Hurry, a director. FINRA claimed that Mr. Hurry indirectly owned Scottsdale, as well as Alpine Securities Corporation, Scottsdale's clearing firm. According to FINRA, Mr. Hurry deposited the shares into accounts and sub-accounts at Scottsdale in the name of CSCT, an account that he owned and controlled. FINRA claimed that Mr. Hurry used the three firms he allegedly controlled, CSCT, Scottsdale, and Alpine, to facilitate the microcap liquidations. None of the shares of the relevant companies were registered with the Securities and Exchange Commission or exempt from registration as required, claimed FINRA. FINRA said that Mr. DeBlasi was responsible to implement and ensure that all relevant stock certificates were validly issued and owned by its customers, and that resales were made in reliance on an exemption for registration requirements in order to prevent the sale of unregistered non-exempt stocks. He was charged for allegedly failing to fulfill his obligations in connection with the relevant microcap liquidation. FINRA seeks findings of rule violations and disgorgement of all profits against the respondents, among other sanctions. And finally, the SEC filed civil insider trading charges against Sean Stewart and his father, Robert Stewart, in a federal court in New York. Simultaneously, federal criminal charges were filed against the father and son in the same court by the United States Attorney's Office located in Manhattan. The SEC alleged that, on at least 6 occasions from 2010 to 2014, the son provided trading tips to his father on future mergers and acquisitions in breach of duties he owed his investment bank employers and the companies they advised. The son worked at 2 different investment banks during the relevant time. According to the SEC, the father used an unnamed third-person friend to place the relevant trades based on the inside information. The father and his friend made approximately $1.1 million as a result of these transactions, said the SEC. Some of this money was kicked back to the son, including his payment for part of his son's wedding expenses, claimed the SEC. The SEC seeks disgorgement of profits and civil penalties against the respondents. The respondents were charged criminally with multiple counts of conspiracy to commit wire fraud, securities fraud, and fraud in connection with a tender offer. Each charge could result in a maximum imprisonment term of 20 years for each respondent. Well, that's it for this week's edition of Bridging the Week. As always, there is more information in each article, and more articles on the article version of Bridging the Week on the website. Check it out. Until 2 weeks from now, this is Gary DeWaal. Have a great week and Memorial Day holiday if you are in the United States, and ciao!